Okay, but I'm going to be blunt with you, Mr. Houston. That text messages changes everything as far as what you said in your declaration is a material omission by that, what you said in that text message to them. It changes the whole texture of what you alleged in your declaration under oath. Good morning. This is the time set for case D21D. We have parties in their counsel in the courtroom. So let's have Mr. Houston, you want to make your appearance first, please?
Dylan Houston, bar number 13697.
Ross Evans, bar number 11374, and attorney Dana Dwiggins for interference is also on Zoom.
On Zoom, and then
there's a paralegal from our office, Your Honor.
Right. And Mr. Downs, do you recognize that? Are you appearing on this case? Oh, okay, perfect. Thank you. All right, so I've read everything except for the reply that was filed on Saturday. I did not read that. I didn't see that until this moment. But I'm ready to rule on this case. The court has exclusive continuing jurisdiction over all matters related to the custody and care of the parties to minor children. The last custody order is the stipulation and order that was entered on January 30th, 2025. At this time, the maternal grandparents and father share joint physical custody with a week on, week off schedule. The standard to modify that would be found in the Romano case, and there has to be a material change in circumstances affecting the well-being of the minor children since January 30th, 2025, and the requested modification must be in the best interest of the children. So, Mr. Houston, like I said, I did not read your reply, and you may have answered this question in the reply, but the text message for on Friday, July 25th that is attached as an exhibit to the intervener's opposition and counter motion. Are you contesting the authenticity of that?
No, but I understand that they are latching on to that, which was never brought up by the interveners themselves. That argument was brought up by their counsel. The text message from myself after I sent that text message was that she respected my decision to tell the children on my own, that they did not want to tell the kids at their residence. And so I understand after the fact, their attorneys have grasped onto that. But just because they're free to do something, because I can't police every action that goes on in their home, doesn't mean that it's in the best interest of the children, or that I can't come in after the fact and disagree with what they did. I mean, they could have their kids jump off the second story roof and jump into their pool, but if they broke a leg, I would be in here saying that that was not a good exercise of judgment by the interveners, which is exactly what transpired here. They undermined my role as the children's sole parent by having this discussion with the children without me present, against my wishes. And what is clear in this case, and what will be the case going forward, is that the interveners do not understand that their role is to support me as the sole parent, and they get to have visitation, but not to determine fundamental parenting issues that affect the children's work.
Okay, but I'm going to be blunt with you, Mr. Houston. That text messages changes everything as far as what you said in your declaration is a material omission by that, what you said in that text message to them. It changes the whole texture of what you alleged in your declaration under oath. And you should be very careful about that, as you're not just a pro per. You are a licensed attorney, and you should not have made that material omission. So it changes everything. They did not do it without your consent in there when you said to them, you guys are obviously free to discuss it with them as you wish.
The implication there would have been after I had my discussion with them, not that they could jump the gun. They could do this without my consent. This isn't even a true concern of why it should have been done immediately. The concern that some 5 or 6 year old is going to disclose this fact to them at school, if that was an ongoing concern, then they should have had that concern the entire time the children have been in school. There should have been clear understanding of what we were doing in regards to this situation,
Okay, but
which
you're-
there was not. There was a lack of communication, a lack of understanding, and they, if you look in their opposition states the reason that they did this, which is what they did after telling me that they agreed I should do it. Interveners were concerned Dylan would either A, not provide the correct information, would not communicate with the children appropriately in the recommended terms and framing, or would not tell the children at all, but would lie and say he did. Moreover, interveners' concerns were heightened given their awareness of Dylan's vitriol and hatred he directed towards Ashley and Dennis during this proceeding, and that Dylan expresses sympathy towards his father despite his actions. Well, with all that in mind, how are the parties going to continue to work together if we can't, if they have no trust in me and they lie about what they're going to do and what their actions are? They said they will defer to me as the parent and they respect that decision. And then they go ahead and tell the children, they don't inform me that they did it before or after. Obviously, they could have sent a text at any time. Hey, you didn't respond. We're planning on telling them. What do you think? They had no communication on that issue before or after. They simply just dropped the kids off to me without warning, and it had a detrimental effect on the children. And I'm sure it still does because
Well, and I'm sure that the failure to follow professional therapist's advice to get them right in also had effect. You can sit down, Mr. Houston. I'm not done making my findings and orders. You also did indicate in that same text message that you agreed to tell the children how the deaths occurred in language appropriate for their age. In this day and age, with this technology and with everything that's out there in the public about this tragedy, your children are going to find out, and they should have found out. And I agree with the therapist's recommendation that they should have been told from the beginning that fact, because what it does is affect your relationship and their relationship with the children, because they're going to feel like they were lied to when they do find out. And when somebody tells them and says, "Oh, here, your parent."
by the interveners because I didn't have possession of the children at that time.
I understand that, but your failure to even reference that text to the maternal grandparents or attach it is a material omission that makes your sworn declaration misleading and the motion without merit or good faith. Dad's motion to modify the current custody schedule is denied. There's not been a material change in circumstances as it relates to the well-being of the children. The counter motion for attorney's fees and costs is going to be granted under NRS 18010. Subsection B2 and EDCR 5.519. It was a frivolous motion. Mr. Evans, how much are you charging per hour?
Your Honor, my rate is $4.50 per hour. I drafted the opposition and appearing today, Your Honor.
Okay, and how much time have you billed from?
We don't have our billings in yet. I can supply the court with a fee memorandum.
I don't need that. What's the rough?
I can estimate that it was 4 hours, Your Honor.
All right, and then appearing today and doing the order. I'm finding that $450 an hour, Mr. Evans' experience is reasonable based upon this market here, and that the hours spent, I'm going to find that $2,000 is a reasonable amount of attorney's fees. Mr. Houston, you got a choice. Do you want me to reduce that to judgment, include interest, or do you want me to set you on a payment plan for that?
I would like an order that I can appeal because certainly are we going to address the part of the motion where I can change therapists? Or
I'm getting to that next.
Okay.
That $2,000 would be reduced to judgment, accrue interest at the legal interest rate and collectible by all means. As far as the therapist, but for the stipulation and order, Dad is right that it would be his sole decision about counseling and a counselor for the children. But he agreed in a global settlement where there was give and take on both sides that the children would attend therapy with Miss Fife and follow her recommendations as to frequency and when to exit the children from therapy. Adults can differ with different experiences, have different opinions about issues. That does not make either party wrong or someone incompetent. Ms. Weiss has been a therapist for about 30 years and has come to her opinion based upon her training and experience. There's no good reason to modify the terms stipulated to by all parties just in December. And if a counselor is going to be changed, there's a right way to do it, to transition any patient from one therapist to another. Therapists retire, they move out of state. There is a process to transition them appropriately. You don't just cut off the therapist, especially once you knew that the children had been told in the language agreed upon about exactly how the deaths occurred. Emma has been seeing Ms. Fife for looks like a full year on a almost weekly basis. I don't find that's in the best interest of the children. Dad is right, though, about the children missing school ongoing for their therapy. So have you guys talked to Ms. Fife about whether she can do her therapy appointment later so they don't miss school?
I did, Your Honor. Ms. Fife can change the therapy appointment to accommodate the children's school schedule, and she's waiting for Dylan to approach her to discuss that with her. If
I
the
mean,
relationship will be going.
That's completely absurd because I've tried to change that time for 8 months since this was entered into, and she informed me she had no availability any other time other than Wednesdays at 3 p.m. on multiple occasions.
Now, I don't know how far back he's referring, but Ms. Fife just told me that, and she's communicated to the pages that 5 p.m. on Thursdays is available right now.
Okay, so the children are going to return to therapy with her immediately. Who has the children this week?
I do.
Okay, what I'm going to do, and it's really kind of cutting the baby in half here on this therapist issue because we're not going to get bogged down on it. But you made an agreement, Mr. Houston, that you felt within the best interest of your children to settle. There was give and take. So they will go back to Ms. Fife immediately. I want her to prepare Emma, and to the extent necessary, Jack, to start going every other week so that we don't have a conflict. The maternal grandparents on their weeks will take them. She's to do that by September 30th. So Dad, you have to take them on your custodial time until September 30th. Then we'll get Emma, and if necessary with Jack. I don't know where she is exactly on how much therapy he needs right this minute. I know she did want to meet with both of the children to process the new information that they received about how. I mean, again, people try to protect their children from the truth sometimes, and then that backfires when they learn the full truth and they think you're a liar as a parent. That's not good for your long-term relationship with them. It's not good for them to feel like everybody in my life lied to me about what happened. Yes, it has to be couched in terms they are 5 and 7. It has to be in terms that they can understand and do that. And it doesn't need to lay blame anywhere, but there's facts that are out there so much in the public. And these children are learning how to use the internet much younger than any of us in this room ever did. And and kids are cruel, and they will tell them, and they will show them, here, let me show you on my phone. There are 7, 8, 10-year-olds that have cell phones, smartphones, that they will do it. And it's unfortunate. We would like to protect them from the harsh reality of the world, but it's hard to do that these days. So I'm ordering Mr. Houston to sign whatever Ms. Fife asked him to, or communicate with her in writing, that per the court order, she is to resume therapy with him ASAP, and you need to do that by no later than 5 p.m. tomorrow. Ms. Fife also needs to get them ready to transition to a new therapist, because in January of 2026, when the custodial schedule changes, it's going to be hard for me to enforce the stipulation in order. It's better for us to process this in a organized, thoughtful manner to get them to transition to every other week, so we don't have to fight with Dad doesn't want to take them. That's fine. We'll get there. And then by January, they need a new therapist. So you got to talk to Ms. Fife about how to transition them. And sir, you have the health insurance for the children through your employer, right?
Correct.
Okay, so you need to provide maternal grandparents with the name of 3 therapists who see children and are taking new patients that'll be covered by your insurance, and do that by no later than September 8th. And then they will have 2 weeks to check them out, and they'll pick one of those 3 that are on your insurance. They'll let you know that in writing by September 22nd. And then they can let Ms. Fife know, and so she can get them prepared. The payment will continue to be 50-50 for Ms. Fife so long as she's doing that. When the new therapist is in place in January, then as the sole parent, dad will be paying 100% of the out-of-pocket cost. But I find that given everything that's occurred, I mean, even before April 8th, your children probably needed therapists because they were the subject of very hotly contested custody. And even as young as they are, they know when their parents don't get along. They know that their parents are in court. But after the April 8th, they definitely need the therapy. And I'm not going to give you, because you agreed to these things, Mr. Houston, I'm not giving you the sole decision-making authority over that. I'm going to keep your kids in therapy until their therapist says that they don't need it any longer. That can happen sooner or later. Emma's already been in therapy a year. So maybe they don't need it in very long, but right now they need it. And it's in their best interest to do that, and you need to participate. So you have issues with Ms. Fife. I am in part granting your motion, but in a slower progress than you would like. So that by January, when you have the sole responsibility of taking them to their therapy, because it'll happen Monday through Friday, then you'll be with a different therapist that you have a say in picking, and that's covered under your insurance. So the co-pays will be reasonable for you and you'll be paying that. Is there anything else we need to, I think that covers all the issues raised in both. Mr. Evans, do you have anything else?
No, Your Honor.
Mr. Houston, you have any questions or clarifications you want to ask?
Nope.
All right, then, Mr. Evans, you're going to prepare that with the detailed findings in that. Then Mr. Houston can take any actions he wants to take on that. And this case will be reclosed for the time being. I know that what I'm asking everybody is difficult. This whole situation is difficult, but these two children are worth it. They are worth having the best childhood they can have in light of the tragedy that's happened, and they deserve to be supported with their mental health because of this. It can't help but affect them. All the adults that have been in this situation in this family are affected. Every one of you are affected by this tragedy, but your children are little and they need that support on that. So I
And
find it
think all
doesn't
the
hurt.
adults are still struggling to process this, which is why 5 and 6-year-olds shouldn't have been told this without their dad present for the second time.
Well, and you guys should have sat down and done that together. That's probably, if I had my wishes, if I could wave a magic wand and make what I want happen, is that you guys would have sat down, and I understand them not wanting to do it at their house, and it'd probably be better for everybody in this case to do it in a neutral place and sit down and tell them. So you all are on the same page on that. And the exact language used on that, because it doesn't help them to put blame on anybody. As adults, we may have our own opinion on what happened. Everybody has their own opinion from their own experience, their own relationships, and that colors what you guys all are doing. It can't help but color that. You guys are human beings. But for the children, they need the facts in as neutral way as possible and in a way that's understandable to them based on their ages and maturity levels. I wish things would have happened differently, but I don't think that is a material change that changes what we worked on to coming up to an agreement to settle the issues that were before the court. Everybody, if you guys would have done the trial that day, everybody was at risk of losing everything. And when you guys chose to compromise and come to an agreement that you could all live with, that's good for your children as well. Staying out of court would be great for your children as well. So I'm hopeful that I don't have to address any further legal issues in this case would be great. And the better you guys can get along. Mr. Houston, if you have, I know I recommended for other reasons as well that you continue to do on individual therapy. So you can be the best parent for your children. You can be the best version of
He's one
you.
of the people that said that it was crazy that they did this. So, I mean,
I get you disagree, and you have every right to disagree. Unfortunately, I have to make the decisions based on what's in front of me, and that's the decision I'm making. I wish you guys all the best on that, and I hope that I don't have to deal with court issues until at such time I know that we have the guardianship of the estate. That'll have issues that eventually come up, but we'll go from there. Thank you all.
Thank you.
thank you.